Welcome to Aging Insight with your host, John Ross and Lisa Schollmeyer. This program is made possible by
Welcome everyone to Aging Insight. I'm Lisa Schollmeyer. I'm here with John Ross, and we're here to bring you information and answer questions that you've always had in your mind, but maybe you didn't have an opportunity to ask, or maybe you just didn't want to haul yourself all the way to the lawyer's office to ask those questions. But we try to listen to our clients and community members and bring those answers to you here on this program.
Yeah, and we see a wide range of stuff, and we have to know a wide range of stuff, all to be able to bring you the kind of information that we think you need. And as elder law attorneys, we do a lot of different things. We do some real estate, we do some government benefits, we do some estate planning. And that's probably one of the bigger pieces of it right there. And when people think about estate planning, they often think about wills.
Yes, getting a will.
Although that's not necessarily the best way to plan your estate, it is probably the most common way that people plan their estate. And you know, I think most people understand that if you've got a will, then when you die, you're going to have named in that will an executor.
Right, and this is often a big decision for people, who's going to be my executor. When you go to name an executor, I do wills for younger couples with young children. It's a big issue for them because they need their executor to take care of dispersing their property for the benefit of their young children. I also do wills for older folks who maybe they feel like none of their adult kids are trustworthy or capable of serving as an executor, but yet their own siblings or peers that they would select as an executor are near their own age, and so they feel like, well, maybe that's not a good option. But a lot of people they do spend almost as much time on who is going to serve as their executor as they do on who gets what property they put in the will. So naming an executor and having some confidence that named executor can take care of your business after you're dead and gone, it's a big decision.
That's right. And so what happens then after that person names that executor? And now they've died, and you find out it's you.
Right. And I will tell you that some people, John, when they draft a will, they do ask the person that they want to serve as their executor, and they say, hey, do you mind if I name you in my will as the executor? And so there's been some communication.
Right.
But in other cases, a person who's done a will, they've kept it very hush-hush. The fact that they even did a will, maybe they didn't want to share that with any of their family.
Right.
So they certainly haven't mentioned to the person they've named as executor that they intend for that individual to carry out that role. So there have been a few times that it has been a complete surprise to an executor, or even if they knew they were the named executor. John, that is not a role that people play every day.
That's right. Yeah, so if you're that named executor and now this person has died, you've got to figure out what is it that you need to do. And typically the first thing, of course, I guess, is decide if you're going to do it. Because this is a big role. As the executor of an estate, you have some obligations. And one of those is a fiduciary duty. We've used this term before on this program. The fiduciary duty means you've got to act in the best interests of somebody. And if you're the executor, you're actually acting in the best interests of a lot of potentially different people with different opinions and different interests. So for example, yes, you have the beneficiaries of the estate. Maybe that's your brothers and sisters. or maybe it's your stepmother, or maybe it's some charities. But you as the executor are going to have an obligation to act in all of their best interests. But not just that. You actually have a fiduciary duty to the estate itself, a duty to preserve the assets and manage those assets as a reasonably prudent person would. So you've got a duty to manage the assets of the estate. You've got to manage all the conflicting interests in all of this, and you've got to do it without any regard for your own self-interests or any of that sort of stuff. So the first job is to decide, are you actually going to do it? Because you don't have to. You know, Lisa, there's no indentured servitude.
That's right. If you are named as an executor, you're not required to serve. Maybe you feel honored, but maybe you have things going on in your life that once you realize all the tasks that you're going to have to do and all the people you're going to be dealing with, maybe this isn't the right job for you to perform at this time. That's okay. You can certainly decline to serve as the executor. And John, that is why in a will, we often draft a first named executor, and then we'll say in that will, if that person cannot or chooses not to serve, then as a second choice, I name this person.
Yep, and you can have as many alternates as you like. Yes. So if you think nobody's going to want to deal with your mess, then you might want to put a number of people on that list. So yeah, you don't have to do it. And if you, but then the second thing is if you're this named executor, okay, now you've decided, you know what, yeah, here's this will, they've named me as the executor. I understand this is a big deal and that I'm going to have this fiduciary duty that I could potentially be held liable if I violate. But no, I think I will take on this role as executor. Really, the next thing you're going to have to figure out is there even a reason to get appointed as the executor?
That's right.
Is there an actual job for you to do here?
That's right, because you know, an executor is a role that is named in a last will and testament. And as we've discussed on this program before, there are many instances where there is no need, there is no necessity to probate that will and name an executor. So, John, I think we'll take a break and we'll come back and kind of talk about how you would figure that out and then what the next steps you would take if it turns out you do need to probate that will. So we'll be right back.
My fellow Americans, I'm Kate, 4 States Furniture's #1 fan, and I'm running for president. I imagine living in a world where there are no donkeys, no elephants, just beautiful furniture. So join me and cast your vote for savings. Woo!
I'm Kate, and I approve this message.
Welcome back to Aging Insight, everybody. I'm John Ross here with Lisa Scholmeyer, and today we're talking about what happens if you get named as an executor. If you've been named as an executor, and during the first segment we said that the first thing is you're going to have to decide you really actually want to do this. But the second thing is, okay, yeah, you're honored to be the executor. Mm-hmm. Do you actually have a job to do?
Right.
Right? Just because you're named what, and here's I'll give you what if your best friend here has named you as the executor?
Okay.
Right? Best friend, you really want to honor him. Now, you don't necessarily appreciate his lifestyle choice because his lifestyle choice was that of a hobo. And he would ride the rails, didn't own a thing in the world, no bank accounts, no real estate. All he had was a little lunch pail with a half-eaten sandwich in it. Okay. Now, he's left that half-eaten sandwich and the lunch pail to a charity.
Okay.
In a will and he's named you as the okay, obviously this is an extreme example, right? But there's no need to go through the process of getting yourself appointed as the executor for this hobo.
Well, and we see this come up, excuse me, we see this come up more frequently in situations where, you know, maybe Aunt Sally, maybe you're Aunt Sally's favorite nephew, and Aunt Sally told you 10 years ago that she drafted a will and she named you as executor, and she wants you to serve in that role. But by the time Aunt Sally passes away, she had sold her house. She was living in a retirement community, an independent retirement community where she just paid rent. She had put all of her money in the bank, in a bank account where she had designated pay on death beneficiaries on that account. And maybe she had even quit driving and didn't even own a car at that point. So in that case, Aunt Sally has some furniture, some clothing, some knickknacks, and a bank account that already has beneficiaries designated. And John, if the executor comes into the office and says, well, you know, the bank account, I've talked to the bank and they've already got that figured out because Aunt Sally had named beneficiaries, but what about her TV and her dresser and her queen size bed and her clothes? Am I going to have to probate a will and get appointed as an executor to deal with all of that stuff?
It's probably just not worth it.
Right.
And now, I say that it's probably not worth it, but let's just kind of be clear here. Because just because you are the named executor, you're not actually the executor.
That's right.
Until that will has been admitted to probate by a court, and the judge of that court has said, one, yes, this is a valid will, and two, based on the testimony and everything else, that you are eligible to serve as that beneficiary.
As that executor.
I mean, as that executor,
Yeah.
sorry, yes. And so, you know, people often miss that part of it. They think, oh, well, just because I'm the named
That's right.
executor, I am the executor. No, no, no. That is the deceased person has made a recommendation.
That's right. That's all naming an executor means in a will, is the person who made the will is recommending that this person named is serving as the executor.
You know, and we see this in the office quite a bit, where we get, you know, maybe the sister or the brother comes in and they say, well, you know, Dad died and my brother's the executor of the will and he's already taken everything out of the house and he's already done this and he's already done that. And I'll say, well, you know, what court was the will filed in?
Yeah, what judge appointed him as the executor?
And well, my brother said, we don't have to probate the will. Well, if the will hasn't been probated, the brother's not the executor.
And it just means the brother's stealing stuff.
Which means he's stealing stuff.
So,
you know, so let's, okay, so going all the way back now, you've decided, yes, you want to do this job. Yeah, I'm going to be the executor. And you've figured out, well, you know what, maybe there's some real estate that was just in this person's name, or bank accounts that were just in the person's name, or other assets. And so now we do have this necessity to probate the will and get appointed as the executor. Okay, you're the executor, but you're a smart guy. I know you. You watch the show. You're smart. You say, I've watched every single episode of Aging Insight they've ever done for 6 years, and I've paid such close attention that I know I could do this myself.
yeah, okay, well, first of all, there's so many tiki rules. There's no way you could do it yourself. But more importantly, in the state of Texas, you are not allowed to go in front of the court by yourself as the nominated executor and ask the judge to appoint you. Under the rules, you must have an attorney. And John, this sounds so self-serving.
It really does. Every time I give a speech and I talk about this, I say, I promise I did not make these rules
That's right.
up.
I didn't lobby for these rules. But the reason the law has been written that way is because many people don't understand what the role of executor is. And so the courts are worried that someone who's appointed as an executor won't understand their role to be a fiduciary and to act in the best interest of everyone that's part of this estate. And you know, John, both Arkansas and Texas, they have thick books of statutes that cover the requirements that an executor has to carry out. And I have to refer to the books quite often. So as a layperson being named as an executor, I guarantee you don't know all the rules, and you will end up getting yourself in trouble and getting sued. So it is best and required that you have an attorney that you hire to guide you to comply with all the rules as you carry out your job as executor.
That's right. So step one, now that you've determined you're going to probate this will and get yourself appointed as the executor, step one is going to be hire an attorney. And that's not just self-serving, that you really are going to have to do that. And then that attorney, they're going to submit that will, they're going to set this deal for a hearing, and at that hearing, you as the executor are going to have to show up, and you're going to have to get up there and raise your right hand and swear, and you're going to swear to a couple of things, that you're qualified to be the executor.
Sure.
So, you know, you're not a crazy person, you're not a felon of some sort, you're not, you don't owe the person any money.
That's right.
The deceased person, you can't have owed them any money.
You're not bankrupt.
Yeah, you're not bankrupt. So you gotta have to show that you're the kind of person that could do this job, and that you're not disqualified in any way. And then, assuming the court finds the will to be valid and you not to be disqualified, the judge is going to say, okay, now you're the executor.
That's right. So, gosh, John, it took us 2 segments to get to the point of getting appointed as an executor. Now what? So we'll take a break. Stick around. We'll talk about that in our next segment.
The Wadley Senior Clinic has been such a blessing for our family. Because they specialize in geriatric care, they take the time to really focus on Dad's needs. Their exam rooms are specially designed for seniors, and they offer lab and x-ray on site. With monthly educational programs on health and wellness of the mind and body, our healthcare questions get answered. Best of all, they accept Dad's Medicare benefits. See what the Wadley Senior Clinic can do for you. Wadley Senior Clinic, where healthy relationships begin.
Welcome back to Aging Insight. I'm John, here with Lisa, and today we're talking about what happens when you have been nominated in a will to be the executor. And, you know, of course, decide if you're going to do it. And if you are going to do it, decide if there's even a necessity to do it. And then once you've figured out, yep, I'll do it, and there's a necessity to do it, then you're going to hire you an attorney.
Yeah, you're going to hire an attorney, and let me add, make sure that attorney does this kind of thing on a regular basis.
No, that is actually a good point. This is not the, I'm going to go see the guy that did my divorce in 1978. Yeah. Or I'm not going to use the guy that got me out of that DWI 3 years ago. Of course, if you have a DWI 3 years ago, you're probably not going to be the executor anyway. But yeah, find somebody that knows what they're doing. Probate is unlike most other areas of law, and it's a highly specialized practice. Most good attorneys that don't practice probate will not practice.
And they won't take your case.
And they won't take your case.
Those are the good ones.
And so, yeah, if you did call that family law attorney and say, hey, I need to probate a will, they should be telling you, hey, I'm a family law attorney, don't do probate, go see somebody that does. So yeah, get you somebody that does. And then that attorney is going to file the will. There's going to be a hearing. At the hearing, assuming everything goes well, then the will is going to be admitted to probate, and you're going to get appointed as the executor. So now you're the executor, but frankly, your job has just begun.
That's right. So once you get appointed as an executor, that thick book I talked about in the previous segment, there are lots of rules and timelines that have to be complied with, where you as an executor have certain duties to carry out during certain timelines. So that's where having an attorney that knows what all those rules and timelines are going to be a lifesaver. Part of getting appointed as an executor is you are going to swear an oath to the court that you will faithfully and properly carry out all of your duties and obligations as an executor. So often some of those very first duties as an executor, you've got to give notice to all the beneficiaries that there's a will and that you're proceeding forward as an executor. You also have an obligation to give notice to creditors, even if you don't think there's no one that the deceased owed any money to. There are still rules about publishing notice to creditors, and you have a very short timeline to get that done. Also, you've got to collect and protect whatever the assets are in the estate. John, one of the big things that I see as a problem often in estates is I have the family member that was named as the executor. Once we got named as an executor and we talk about, well, what assets do we need to gather up, protect, keep insurance on? And often the executor will tell me that, well, my brother is driving my mom's car.
Right.
And the car is part of the estate, but a beneficiary is out there driving the car.
Right.
Well, the executor, I have to tell that executor, we got to get that car back, because that car is until we get to the end of the estate, that car doesn't go to anybody. And also, if someone's out there driving it around as an estate asset, they get into a wreck, then that could put all of the assets of the estate at risk. And of course, if someone's driving around and putting miles on it, then that is diminishing the value of that car. We don't know what's going on with that asset. So as an executor, you get to go, you call your brother, tell him to bring back the car. I've even had to have executors essentially repossess vehicles because another family member had taken off with it.
Yeah, so you do have this obligation to gather up and protect all of the assets. And yeah, that can be uncomfortable in a lot of the situations, but understand that, like in this case where you got the one kid that's out driving it around, if that kid gets into a car wreck, not only could you be sued for letting them drive the car by whoever they wrecked into, but you can also then be sued by your other brothers and sisters for letting that asset go away and be crashed while your job was to try to protect it.
Yeah.
So you could actually get doubly sued for the same thing that you didn't even cause, and yet, but that's this whole idea of you're in charge. And the person in charge, they get held responsible when things go bad. And so, yeah, you've got to gather up these assets. You've got to notify creditors. Say, hey, if this deceased person owed anybody any money, now's your time to get paid. You've notified all the beneficiaries. But now that you've gathered up all these assets, you need to make an inventory of them. And that inventory has to be filed with the court.
Right, and so there's a particular form that the court wants to see. There's particular types of assets that are part of the estate that have to be listed on that inventory. And the other beneficiaries have an opportunity to object to the inventory if they feel like there's something missing or there's a value that you got wrong on that inventory. Then other beneficiaries can object to the inventory that you file with the court. But that's just another one of those duties that have to get done by the executor, and you do have a timeline to get that filed.
That's right. So you're gonna get appointed. You're gonna file this inventory, and meanwhile, through this process, you're managing the estate. You're making sure everything's protected. Everything's under your control. You're waiting to see if any creditors come in. And then, once a certain period of time, somewhere typically between 4 to 6 months, you're going to now know, here's everything we started, Here's the expenses we had along the way. Maybe here's some income we had along the way. Here's the bills that we had to pay. And you've done all of those things, and now you can finally go back and make a final distribution to everybody. And at that point, you're done.
Yeah, you file some closing reports with the judge, get those approved by the court, and then you can get discharged from your job as being executor. But most folks are going to serve in that role. You're going to have that job as executor from anywhere from 6 months to 2 or 3 years, depending on the nature of the estate that you're in charge of.
Yep, so it is a big job. It does potentially subject you to liability if you don't do it right. And it's going to take a long time. Yep, you can get paid, but I wouldn't plan on getting rich off the deal. So it's a big decision, certainly something that you would need to think carefully about. We hope you've enjoyed the show. Hope you learned a little something in case you are ever named as the executor of a will. And if you have other questions, you can always just keep watching Aging Insight. We'll answer them all eventually. See you next time.
Bye-bye.
Thank you for joining us for this week's Aging Insight program with John Ross and Lisa Scholmeyer. This program is made possible by